Next, meet 34-year-old Timothy DeMatteo, a rock musician from Florida who found himself in the courtroom spotlight for all the wrong reasons. Facing charges of petty theft and property damage, DeMatteo allegedly tried to steal nutritional supplements and caused a scene when caught. True to his rock star persona, DeMatteo decided to turn his court appearance into a performance. With dramatic flair, he declared,
to pick up my scripts. They said it was a 45-minute wait for some reason. I'm walking around shopping. I go to the bathroom to take a piss and wash my hands, and the manager's in there waiting for me, thinking I'm shoplifting. I wasn't shoplifting anything.
No?
No. My first, second, third, fourth, 13th, 14th Amendment rights have been violated.
It was clear he was channeling his inner rock star, but the courtroom wasn't the right stage for his antics. His impromptu performance came to an abrupt end as court officers intervened, forcefully removing him from the scene. Despite the courtroom drama, DeMatteo later pled guilty to the petty theft charge. He was ordered to pay $293 in restitution, bringing his courtroom concert to a final, quieter close. Darl Brooks faced sentencing in Waukesha, Wisconsin for his harrowing actions on November 21, 2021. At approximately 4:39 p.m. CST, Brooks, driving a red 2010 Ford Escape SUV at around 40 miles per hour, breached barricades and drove through the Christmas parade. His path of destruction claimed 6 lives and injured 12 others as he sped through a crowd of 68 people before finally stopping.
Through 68 different people. He kept going until he got to the end.
The shocking event, broadcast live and captured on social media, showed chaos and distress. Eyewitnesses described the driver's actions as deliberate, maneuvering in a zigzag pattern to maximize the number of people hit. The scene was filled with screams and cries, while one observer noted that Brooks appeared unnervingly calm and composed throughout the attack. During the trial, Brooks chose to represent himself, refusing legal counsel and frequently causing disruptions in court. His behavior reached a peak of absurdity during an argument over the pronunciation of the word defendant, leading to a tense stare-down with the judge.
I would like to provide the defendant and the court.
So that had to be said. The defendant. I got one ear that work and I heard that.
This is to benefit you,
so
that you understand your witness.
This outburst, alongside multiple courtroom expulsions for interruptions, showcased his disregard for the proceedings. Throughout his trial, Brooks was frequently escorted out of the courtroom due to his repeated failure to adhere to courtroom decorum. His disruptions included frequent interruptions, argumentative behavior, intense glares, and various outbursts directed at Judge Doro. On October 24, 2022, Darl Brooks was set to present his defense. However, due to his ongoing disruptions and failure to adhere to courtroom rules, Judge Doro decided that Brooks had forfeited his chance to call additional witnesses, including his mother. As a result, the evidentiary phase of the trial was concluded. Judge Doro also remarked that Brooks displayed a complete and utter lack of remorse. He barely offered an apology and, at times, even mocked the victims with dismissive hand gestures and eye rolls. Despite his erratic behavior, the jury delivered a verdict of guilt on all 76 charges. Brooks received 6 consecutive life sentences, along with an additional 700 years, reflecting the gravity of his crimes and ensuring he'll spend the rest of his life in prison. We turn now to Orangeburg, South Carolina, where a critical bond hearing is underway for 26-year-old Maurice Hall. Hall faces severe charges, including attempted murder, using a weapon during a violent crime, and possessing a firearm as a convicted felon. His arrest is linked to 3 separate shootings, one of which took place just days ago at a crowded nightclub. Hall allegedly fired a shot in the midst of the crowd, but that wasn't the first time he was on law enforcement's radar. 2 other incidents were already under investigation, including a terrifying shooting at a residence where a 3-year-old child was present. Today, Hall is in court, hoping to secure a release on bond. However, he's up against representatives from 3 different law enforcement agencies, all unified in their stance. They believe Hall should stay behind bars. From the start, Hall's frustration is evident.
Man, get me out of the car, man. I don't even want to be through this. You supposed to stay about me, boy. You started it, nigga. I ain't do nothing to you. Boy. Boy. Man, I don't give a about none of that. Boy. It ain't over with. You what? You started it. You got to go home.
The outburst forces security to remove him, giving him a few minutes to cool down. Shortly after, the judge, in a move to maintain order, calls for Hall to return.
All right, Mr. Hall, if I am to do bond today, understand that I'm putting a no contact order between you and the victims and any members of the victim's family. The contact means, of course, no third-party communication, telecommunication, or written communication. Do realize that if you violate that order, you will subject yourself to sitting in jail until this case is fully adjudicated. You understand?
Yes, sir.
As Hall re-enters, he seems more composed. The judge sets clear boundaries, saying, Hall now is visibly calmer. The judge then looks to the prosecution.
All right, anything from the state first?
Yes, sir.
From Bowman first? Yes, sir.
Due to the severity of the crime that has been committed and his extensive record, we would like to ask the court for no bond. We feel that he's a threat to the community, Your Honor.
A second official, representing another agency, adds,
Your Honor, we've got numerous convictions on his criminal history, not just South Carolina, but also North Carolina. He's got a very extensive history, as you've heard from Bowman. Some of the highlights are burglary, as you've heard from probation parole, several assault charges, possession of weapons with convictions. Your Honor, this is a very serious act. Not only just our charges, but Bowman's charges. We're asking for denial of bond also. We feel like that he is a flight risk. He's got ties to North Carolina, as well as he's a danger to the community.
And after weighing the arguments, the judge delivers the decision.
Mr. Hall, based on what I'm hearing, I do feel that this court should defer your bond to be set over in General Sessions Court as opposed to me setting it today, which means that you will be going before the General Session judge in order for that judge to set your bond. You understand me?
Yes, sir.
This particular day and time we're going to deny the bond on the cost. Thank you very much. You understand me?
Yes, sir.
This particular day and time we're going to deny the bond on the cost. Thank you very much.
Hall, looking visibly unsettled, is led back out of the courtroom as he continues to make a few more comments.
I don't need me standing here, man.
Let's talk about Sher Flynn, a Florida native who's in court facing serious charges of felony battery and resisting arrest with violence. Represented by a public defender, Flynn's case quickly becomes a whirlwind of tension and misunderstandings. From the moment the court proceedings start, things take a turn. When asked by the judge if she's ever been treated for mental health issues, Flynn responds,
Have you ever been treated for any mental health issues?
Why don't you go yourself first?
I'm sorry, ma'am?
I said go yourself.
Okay, well, I'm a little busy right now.
The judge, initially finding the situation amusing, soon everything changes.
Hey,
F51
it's right from private gun
count is $5,000. Please to inform it's $5,000 and count 3 is $1,000. Have a nice day, ma'am. Let's try and get you into the hospital.
Flynn is fined $50 and ordered to undergo a comprehensive psychiatric evaluation. Back at Berea Municipal Court, 21-year-old Milton Watts is in a tight spot. He's turned himself in after a warrant was issued for missing his hearing on a domestic violence charge. Arriving in court without a lawyer, Watts hoped he could handle things on his own, despite his evident lack of legal knowledge. Judge Chris Green, known for his straightforward approach, took this opportunity to test Watts' understanding of the legal system.
I don't really give a to be honest with you.
That's going to cost you 30 days in the county jail for contempt, $5,000 cash surety bond, temporary, subject to the temporary protection order.
Already facing a hefty fine and jail time, Watts didn't help his situation. He lamented, saying,
I already ruined my life.
That's 60. You want to go for 90? That's 90 more. That's 180. That's 306.
I'm working at McDonald's. Now I gotta come here and my life up.
you!
Melvin, stop!
How many days you want to give me now? Are you Sir County? Come on.
Yeah, I'm at about a year right now in contempt, so.
While the judge's initial frustration seemed to hint at a much harsher sentence, he ultimately decided on a 90-day term for Watts. The young man, who had dug himself into a considerable legal hole, now faced a 3-month stint in county jail alongside the daunting $5,000 bond. Inside the Jackson County Courthouse, 31-year-old Kamaya Gant faces sentencing for a chilling crime: the brutal murder of her boyfriend, Maurice Hill. Gant was found guilty of first-degree murder after a trial that revealed a gruesome scene. The evidence showed that Gant used a frying pan, a floor lamp, and a large knife to inflict multiple stab wounds on Hill. Despite her claims of self-defense, asserting she mistook Hill for an intruder, the jury found her story lacking. As Gant stood before Judge McBain, the courtroom was abuzz with tension. Judge McBain gave Gant a chance to address the court.
Is there anything that you want to tell the court before I impose sentence? Is there anything you want to tell the victim's family who are here today?
I just want to say that I stick by the truth, which is that I did react in self-defense. I did love Marcel, and basically at trial, the way I was portrayed, mostly everything was lies. There was a little bit of truth, but mostly I was convicted off of lies, and I do plan to appeal it, and that's all I have to say.
But Judge McBain pressed further.
Got anything you want to tell the court about the 12 stab wounds that you did in self-defense?
The alleged 12 stab wounds?
Well, I don't think the pathologist lied about those.
No, I don't have anything further to say.
As the courtroom waited for Gant's sentencing, Marcel Hill's aunt, Diana Banks Joyner, took the floor. Her words were heavy with grief.
You did leave a big hole in our hearts and a void that will never be filled. You took the life of our sister's only child. You took a bloodline out of our family. And we hope that each and every day that you remember the cries of help that he screamed as you plunged that knife in and out of his body.
As she continued, Gant appeared unmoved by Banks' emotional statement. But Judge McBain, clearly frustrated, went ahead and gave her a warning.
So we, the family of Marcel, would like to thank God for the special gift that you will receive today from the judge.
Is that it?
When I finish, I'll let you know.
Oh, okay. Seriously?
You talk again, I'll have my court officer put a piece of duct tape in your mouth. You understand it? Try it one more time and see what happens to your mouth. You got something else to say?
Even with the threat of duct tape, Gamut continues.
I'm done.
Miss Sonia, get the duct tape.
I'll sit here and listen to the lies.
You know what? She's got a right to talk to the court after you murdered a relative of hers. And you're gonna shut your mouth or I'm gonna have some duct tape put on it.
Well, he attacked
me. We'll wait here for a moment till we can get her quiet.
Despite the warning, Gant continued to disrupt the proceedings. Judge McBain, exasperated, ordered a pause to fetch the duct tape. As they waited, Banks continued.
Remember Marcel and the love you had for him as we ask God to teach us to learn to forgive you because there is no love. Amen.
Judge McBain had the final word, delivering a scathing judgment.
This is one of the worst cold-blooded murders I've seen in a long time. You end up ultimately hit him in the head so hard with a pan that you actually cave in the front of his skull, and then you stabbed him no less than 12 times. You gutted him like a fish in that apartment, too. You were relentless. You stabbed, you stabbed, you stabbed, you stabbed, you stabbed until he was dead. I agree with the family. I hope you die in prison as well. You know, if this was a death penalty state, you'd be getting the chair.
With that, Judge McBain sentenced Kamaya Gant to life in prison without the possibility of parole. In Louisville, Kentucky, 27-year-old Brandon Lawrence faces arraignment on serious charges. Violating a domestic protection order and attempted murder, Lawrence is accused of nearly beating his uncle to death with a tire iron. As he steps into the courtroom, the gravity of the situation seems to hit him with an unexpected response. The judge begins the proceedings.
Mr. Lawrence will enter not guilty plea for you today on these charges. Your bond is presently set at $250,000. Why are you laughing?
Instead of showing concern, Lawrence bursts into laughter. It's unclear whether he's reacting to the bond amount in disbelief or as a sign of his frustration. Regardless, the judge remains composed and proceeds to explain a proposed no-contact order, which unfortunately includes Lawrence's mother.
That's my mother. What does my mother got anything to do with? I ain't done nothing to my mother.
Let's see, maybe she was a witness to this, so let's see.
Nobody was around, that's all I'm gonna say.
The judge attempts to clarify, but Lawrence interrupts, frustrated.
I'm going out of your courtroom.
I beg your pardon?
Yeah.
What did you say?
You can raise the bond, do what you want to. I'm going back to my cell.
It seems Lawrence's patience for court proceedings is running thin. The judge tries to redirect the focus.
You can raise the bond, do what you want to. I'm going back to my cell.
Who is your attorney, sir?
Grover Cox.
Okay, are you going to call Mr. Cox on this?
Yep, I sure am.
Okay. All right, so we'll enter a not guilty plea. Oh.
Without further delay, the judge moves forward with entering the not guilty plea. However, as Lawrence heads back to his cell, he slams his fist against the plexiglass divider, startling everyone in the room. The outburst prompts the judge to reassess Lawrence's bond.
Bonds increase to $500,000.
Judge McBain increases the bond to $500,000. Lawrence's actions have not only intensified the charges against him, but also led to a steep rise in his bond, leaving him with even more to deal with as he returns to his cell. In Dayton Municipal Court, 55-year-old Anthony Matthews faces a bench trial under Judge Mia Spells. Charged with driving on a suspended license, Matthews arrives with a firm belief in his status as a sovereign citizen, convinced that the laws of the land do not apply to him. From the outset, it's clear Matthews is ready to challenge the court's authority.
I demand that you dismiss this matter immediately.
Despite his numerous motions aimed at undermining the court's jurisdiction, Judge Spells remains steadfast. She tries to clarify the rules of the court, but Matthews quickly cuts her off.
Let me explain to you the rules here in the court. Let me explain to you the rules of the court, sir.
You're not here to take part in fraud. Not at all.
But the judge warns him firmly. But even with that, Matthews' defiance escalates.
You can be found in contempt if you continue to interrupt me. We'll proceed with trial with you in abstention, sir, and we're going to find you in contempt. What I'm going to do is give you...
That's the record. The court is coercion.
You're interrupting the proceedings of the court, sir, and it is direct contempt. It is direct contempt, and we're going to take you into custody, sir. We will give you a hearing, and you'll have the hearing. We will find counsel for you.
As deputies approach to detain him, Matthews braces for confrontation. Tensions rise sharply, and two off-duty police officers seated in the jury box step in to assist. The situation deteriorates quickly as one of the officers lands several punches on Matthews. Judge Spells and courtroom staff scramble to clear the area while more deputies rush in. In a dramatic scene, 6 people are involved in subduing Matthews, who is eventually restrained with 2 pairs of handcuffs. After several minutes of chaos, he's escorted out of the courtroom. The next day, Matthews returns to face Judge Spells, this time with a noticeably different demeanor.
Yesterday's proceeding was in error on my behalf. I take full blame for my actions.
The court believes the conduct of Mr. Matthews severely threatened the integrity of the court and its proceedings, and such that immediate action was necessary.
Despite this change in attitude, the court views Matthews' conduct as a serious threat to the integrity of the proceedings. Judge Spells sentences him to a year of probation and time served for the original charge of driving on a suspended license and the contempt of court charge. However, Matthews faces additional charges of assault on a peace officer and obstructing official business due to the violent altercation with deputies and court officials. He remains free on bond, awaiting trial for these new charges. Now, let's start at Longview of Washington State, where 45-year-old James Shriver awaits his arraignment. 2 days before, he walked into a grocery store to buy some products, selected them, and picked up a reusable blue sack for carrying groceries. But the situation took an unexpected turn. After paying for his groceries, Shriver allegedly slipped the empty bag into his pants pocket, which was spotted by a store employee. This prompted a call to the police, and after which Shriver was apprehended and charged with third-degree theft. Adding to the complication, it was found that Shriver had previously been barred from the store 2 years back, which made the case worse with another criminal trespass charge. Now here he is, standing before Judge Jamie Enbeden, hoping to get released on bond. And this is how things start.
All right, you are James Shriver, is that correct, sir?
Yes, sir.
You're charged with theft in the third degree.
I'm not gonna say it's total I didn't steal a damn thing. I paid for my items, and I traded.
Mr. Shriver, stop. Shriver, stop.
And I tried to pay for it.
Shriver, please stop talking. First of all, I'm not going to condone the swearing, number one. Number two, I'm not going to condone you interrupting me. Let me finish what I'm doing. If you don't want to let me finish what I'm saying, then I have no choice but to find you in contempt for interfering with the hearing. So, sir, you were charged with theft in the third degree and criminal trespass in the first degree. Each of those are gross misdemeanors. They both carry a maximum penalty of 364 days in jail and a $5,000 fine. Sir, I am going to find probable cause based on the officer's report to both charges. No. Mr. Shriver, do you want me to appoint an attorney to help you out?
But what do you need to call me? Hammer or something?
Shriver, clearly upset, seems to mishear. The judge stays patient, but then...
Do you want me to appoint counsel for you, sir, or not?
Call me. No answer.
All right, I'm not going to appoint counsel.
Yes, but can I just get an answer of what you just called me?
Called me by your name, Mr. Shriver.
Okay. I have no family, everybody's dead, and everybody steals everything from me.
Mr. Shriver, let me finish, please. Would you like an attorney to help you with the case, sir?
Yes.
After a tense moment, Shriver finally calms down, and the judge asks the state for their bond recommendation.
I'm going to enter a plea of not guilty to the charges. Mr. Schuman, what's your position on release?
Release on recognizance.
Ms. Campbell, do you want to be heard?
Your Honor, we would ask that you release him on his personal recognizance.
Just give me one moment to take a look.
However, when the judge checks Shriver's record and finds 14 outstanding warrants from 2021, he's not so lenient.
Got 14 warrants that were issued in 2021. I am going to assess bail at $500.
Shriver, visibly distressed, pleads.
Please, sir, don't. I want to put myself through this. Please, I'm begging you. I have a little lady out there. I need to go take care of her. Please, please. I don't have my. I haven't had a Social Security check in 19 months. I'm doing everything every day. I'm trying to fucking work. I'm trying to hard. Please.
But the judge remains firm.
All right, counsel, we will have, I'm going to set September 1 for pre-trials, and we will deliver to Mr. Shriver all of that information. All right, Mr. Shriver, you can step back, sir.
Am I getting out?
If you post bail, otherwise you can't.
I have no family, everybody's dead. I am scared. You!
Shriver was later taken back to jail. He never managed to post bail and eventually pled guilty to the criminal trespass charge. And his sentence, 10 days in jail, with credit for time already served, and the theft charge was dismissed.
Listen, stop talking. You have been... Are you done?
No, I'm done.
You've been charged with assault in the fourth degree. I'm gonna keep talking because I don't want to have to see you back here for this.
What you think can't find out where you live at? What you think at? I don't about none of that. I ain't do.
It's been nearly 8 years since Bryce Rhodes was charged with one of the most chilling crimes imaginable, the brutal murders of 3 people, including 2 teenage brothers. And now his case has finally come to a close. The judge decided to follow the jury's recommendation, sentencing Rhodes to life in prison without any chance of parole. No escape, no mercy. Back in December, the jury didn't even need an hour to convict him on all counts: the murders, tampering with evidence, and abuse of a corpse. Rhodes was found guilty of shooting Christopher Jones and brutally beating and stabbing 16-year-old Maurice Gordon and his 14-year-old brother, Larry Ordway. Their bodies weren't just left behind, they were burned, an act that added another layer of horror to an already grim story. But Rhodes' path to justice was far from straightforward. He went through attorney after attorney, refusing to cooperate or even threatening them, dragging out the process for years. A mental competency evaluation took over a year, and the pandemic further delayed the proceedings. His behavior in court was a spectacle in itself: threats to judges and lawyers, bizarre accusations of affairs, and claims of racism against court officials. These outbursts only fueled the anger of the victims' families and kept the case in the headlines. The story of the murders is almost too disturbing to comprehend. It all started on May 4, 2016, when Rhodes shot Jones on South 41st Street. A co-defendant, Anjuan Carter, revealed that he was in the front seat while Rhodes, Gordon, and Ordway were in the back. Jones didn't survive his injuries, and soon after, Rhodes heard rumors that the teenage brothers were talking to their families about what had happened. On May 22, 2016, Rhodes decided to silence them for good. According to the trial, Rhodes lured the brothers to his home. What followed was pure horror. Gordon was tied up with a toboggan pulled over his head, while Ordway was forced to listen from the bathroom as his brothers screamed and begged for forgiveness. Rhodes, along with other men present, beat and stabbed Gordon before dragging him away and repeating the nightmare with Ordway. The bodies were dumped in the backyard of an abandoned house and set on fire. Carter, who had stayed behind, later cleaned up the gruesome scene. 2 of Rhodes' accomplices, teenage cousins Anjuan Carter and Jakery Taylor, eventually took deals for lighter sentences, testifying that Rhodes was the mastermind who coerced them into these brutal killings. And just like that, this case, with all its dark twists, reached its grim conclusion. Rhodes faces a maximum sentence of life in prison without the possibility of parole. As we conclude today's gripping courtroom stories, thank you for watching. Stay tuned for part 4, where we'll dive into even more compelling cases and courtroom drama. Don't miss out, subscribe, and keep up with the latest updates.